I'm now going to hand over to Ed Rimmell, partner at VWV in the commercial team, and Ben Holt, partner again in the commercial litigation team, who are going to introduce our next webinar, and that is on force majeure, frustration and contract management. So over to you, Ed and Ben.
Thanks, Emma. Right, so the spread of COVID-19 and the restrictions imposed on our way of life to try to halt that spread has had a chilling effect on business across the world. So in this presentation, we're going to think about the impact that COVID-19 is having on commercial contracts and consider some of the contractual and legal mechanisms that come into play where you or your suppliers are prevented or restricted from performing your contractual obligations due to the coronavirus outbreak. My name's Ed Rimmell. I'm a partner in the commercial team at VWV. And my colleague Ben Holt, a partner in a dispute resolution team, is co-presenting this session with me. As you might imagine, we've been dealing with COVID-19 related questions since early February, including a number from universities. And those queries have ranged from things like event cancellation, supply chain issues where one business has been unable to perform due to labour shortages, through to challenges faced by concession holders such as catering contractors as a result of being unable to access premises from where those services are provided.
Well, see, Ed's caught me out here because he's gone and put on a jacket, so now he looks far smarter than I do. So apologies for my relaxed look. Many contracts will include a provision for dealing with events outside the party's control. Those are often called force majeure clauses. Essentially, they provide a get-out. If the clause is triggered by the events that the clause describes, parties may not be in breach for failing to perform their obligations. The reality is that up until recently, on the whole, those clauses were very rarely relied upon by parties to a contract. We all studied them at university, but to the best of my recollection, I don't recall advising on them at all in nearly 18 years that I've been working as a lawyer prior to the past few months. A lot of the cases relate to things like shipping contracts, with international issues being the force majeure, the event outside the party's control. There simply hasn't been a point in my life when we've had such a widespread event beyond the control of contracting parties. Perhaps the volcanic ash cloud presented a few issues. Probably the only issue of significance to me was that it prevented Blackburn Rovers from signing Robert Lewandowski. He went off to Bayern Munich instead. He scores virtually a goal a game and has won the league 5 times. So I'm sure he's kicking himself over that rather than being at Blackburn. Probably the last big force majeure event across the whole of the UK was the 3-day working week in the 70s. The comparable pandemic that we've had was the Spanish flu of 1918, but force majeure as a legal concept hadn't really reached any level of maturity by that stage. And certainly there weren't as many sophisticated or international contracts around. So legally, these are unique times, and COVID-19 presents us with some really interesting legal questions for which read uncertain and potentially expensive. So generally, a pragmatic and commercial approach needs to be taken. A key point to stress, what Ed and I have seen recently in the clauses, is that they differ quite considerably from contract to contract. You need to look very carefully at what your contract actually says, whether it fits the circumstances and what it requires you to do.
So from the issues we've seen over the last few months, we've identified 2 key themes that crop up time and again with clients that we're advising. I think the first theme, as Ben's alluded to, is that force majeure clauses don't always work in the way that parties assume them to. They work to reallocate risk between the parties, but one party or other is always going to be taking on some or all of the risk associated with the force majeure event. There's a common assumption that provided that you have a force majeure clause in your contract, that you're protected against the effect of the force majeure event. Now that's not a safe assumption. The second theme is that even where a party to a contract has a clear contractual right, we've been seeing a willingness to take a pragmatic and supportive approach in working through the challenges of COVID-19. It'd be nice to think that this is a sign of society pulling together in these difficult times, and there may be an element of that. There's also a heavy dose of commercial reality here, which is that with the challenges faced by businesses as a result of COVID-19, not taking a pragmatic approach risks pushing customers or suppliers into insolvency, which is unlikely to be in either party's interests. So in this presentation, we'll consider how force majeure provisions typically found in commercial contracts might be able to help, and how the legal doctrine of frustration might apply in these circumstances. Before getting into the detail, we should emphasise that this session focuses kind of on the pure contractual position. And Stephanie's talked this morning about additional considerations that contracting authorities must have regard to when considering how to respond to the contractual position. Not all universities will consider themselves as contracting authorities though, and there will be some contracts, for example concession type arrangements, which aren't covered by the PPNs that Stephanie's discussed. And whether covered by the PPNs or not, our view is that you'll need to be clear as to your strict contractual position under the contract first, and that you'll then take a view on how, if at all, that analysis is impacted by the PPNs. Can I have the next slide, please? Now, I always find it helpful to have a scenario in mind when thinking about these sorts of contractual and legal concepts. So for the purposes of this presentation, we'll use a scenario which we've seen crop up fairly frequently, or a scenario along these lines, and that I expect might be familiar to many of you in one form or other. So in this scenario, a university makes its facilities available over the summer holidays for use by a foreign language school. The university is paid by the language school for the use of its facilities, and the amount that's paid is linked to the number of students attending the language school, with some assurances around a minimum fee. The main obligation of the university is to make the facilities available to the language school and to provide catering and housekeeping services. The main obligation of the language school is to ensure the facilities aren't damaged and to pay the fees to the university. Now, the spread of COVID-19 has had two main consequences for this sort of contract. First, the university may not be permitted to open its doors to the language school in the summer, and the language school might not be permitted to run. And second, even if the restrictions were lifted by the summer, the language schools have seen a stark drop in bookings to attend the course. Many attendees are cancelling their attendance. So if you could perhaps keep that scenario in mind as we run through this presentation, we'll refer back to it from time to time.
So first up, let's have a closer look at force majeure. It's typically a clause that comes into effect when an external event occurs so as to inhibit the performance of the contract by one or both parties. It's often thought that it's a standard principle, that it's relevant to all contracts, but there is no standard English legal principle of force majeure. The rules that apply will be the rules that are set out in your contract, and those may have been carefully negotiated when putting the contract together. In the absence of anything in the contract, and subject to what we're going to talk about shortly in relation to frustration, the starting point at law is that the parties to a contract are required to perform their obligations, even if it's made difficult by some external event. A force majeure clause usually works to step in and excuse a party from performance of obligations in carefully defined circumstances. However, a force majeure clause will only work in the way that it's provided for in the contract. The party's protection is only as good as what was provided for in the provision of the clause. So what's frustration? Well, that's not something that's covered by the contract itself. It's an English common law doctrine. It's one that's been developed over time by the courts. And that acts as a device to set aside contracts where an unforeseen event either renders contractual obligations impossible or radically changes the party's principal purpose for entering into that contract. In the absence of a force majeure clause, or maybe where the event is not covered by the force majeure clause, the common law doctrine of frustration may step in to relieve the parties of their obligations. But frustration only applies in very limited circumstances, principally where performance has become impossible and is interpreted very narrowly by the courts. In those limited circumstances, the effect of the contract being frustrated is to cancel all current and future rights under a contract. Next slide, please. So let's have a more detailed look at force majeure. We've established the basics. Force majeure literally translates from French as superior force. I was particularly pleased to get that in, as my French is awful, whereas Ed has a French wife and is fully fluent. They're sometimes referred to as act of God provisions, but that's not really right, as it also covers human interventions. The force majeure clause sets out the rules that will apply where some external event outside of the control of the parties to a contract gets in the way of performance. It's usually the only way to suspend or end performance of the contract on the grounds of events beyond the parties' control. Typically, the clause will provide that where a party is prevented from, or sometimes only hindered, in performing its obligations as a result of an occurrence, the affected party will not be liable to the other for failure to perform its obligations as a result of that event. So in our university scenario, if the university is prevented from making its facilities available to the language school, depending on the wording of its contract, it may or may not be relieved of the liability which it otherwise have had for not doing so. Sometimes, if the force majeure event continues beyond a certain period or time, one or both parties may be entitled to bring the contract to an end. That clause will often attach conditions to the force majeure clause before it can apply.
So what should you look for when considering whether a force majeure clause applies in your contract? First, you need to look at whether the event itself is covered by the force majeure clause, often tucked away in the force majeure definition. Some force majeure clauses list a closed category of events which constitute force majeure. And if that's the case, the event must fall within that closed category in order for the clause to apply. So good examples are clauses usually list things like earthquakes, floods, and fires, and in some contracts they also list epidemics and pandemics as the only circumstances which can constitute force majeure events. And if COVID-19 isn't capable of being interpreted as being within that closed list of events, then the analysis probably stops there. But even where pandemics aren't specifically referred to, the consequences of the pandemic, like for example the imposition of government restrictions, might itself be a specified event which allows you to get within the force majeure definition. But many force majeure clauses also refer to any event outside of the reasonable control of the parties. If your clause works in that way, then even if COVID-19 doesn't fall within the specified list, it's likely to be an event which is outside of your reasonable control and therefore within the scope of the force majeure clause. It's worth bearing in mind that lists of events can be interpreted as limiting the catch-all wording at the end to mean that only events of a similar nature are relevant. For example, a reference solely to earthquake, fire and flood and any event outside of the reasonable control could be interpreted to limit the more general wording of other events to only events which are natural disasters. That might be a harsh interpretation. Of course, it depends on the drafting of the contract and the overall context. But it's a further example of the detail of the force majeure provision, very much depending on the drafting of your agreement. But it's not enough just to show that COVID-19 falls within a potential category of force majeure events. The force majeure clause will almost always require that the force majeure event has had some impact on the performance by the parties of their obligations under the agreement. So you'll also need to consider, firstly, how badly affected must your obligations be in order that you're protected by the force majeure clause, or in order that your supplier is protected. Some clauses require that performance has been prevented or made impossible by the force majeure event. That's quite a high bar to reach in many cases, and won't always apply, even in the current circumstances. Other contracts require that performance has been hindered or delayed as a result of the force majeure event. That's a much lower bar and is probably much more likely to be met by a lot of the consequences of COVID-19. You'll need to think about which obligations have been affected. The contract will contain many obligations on both parties, but unless the effect of your particular force majeure clause is to suspend all obligations of both parties under the agreement, and that's a relatively uncommon consequence of force majeure events under most contracts, and the parties will only be relieved of their responsibility in respect of those obligations that have been prevented by the force majeure event. So in the case of our university language school, the university may well be relieved of its obligation to open its facilities to the language school, assuming that the restrictions carry on into the summer. And if the language school's paying on a per pupil basis and it's committed to the university to ensure that at least 100 students attend at the language school, so that the university has some assurance over its summer revenues, then the language school may well also be relieved of that obligation. But if the language school's payment obligation is simply to pay a fixed amount, or is perhaps to pay the greater of £100,000 and £1,000 multiplied by the number of students attending, then the language school may not be relieved of its payment obligation, even though the university is unable to make the facilities available. This is because the force majeure event isn't likely to have the effect of preventing the language school from satisfying its payment obligation. In order for the payment obligation to be removed, the drafting of the force majeure clause will need to provide for that. So the effect of a force majeure clause is to make clear where the risk of the unexpected event sits. If the risk doesn't sit with you, it will sit with your counterparty. If the university is excused from liability for failing to perform its obligations, and the flip side of that is that the summer school takes the risk of those obligations going unperformed when an event of force majeure arises. So let's have a look at some other typical features of a force majeure clause. Could we go to the next slide, please? So having established that you're within the scope of your force majeure clause and that some or all of the obligations of the parties are capable of being suspended as a result, what are some of the other typical features of the clause that you'll need to think about? The first one is notice. Very often, in order to enjoy the protection of force majeure clause, it's necessary to notify the other party of the force majeure event, setting out the consequences of the event and how performance will be affected. Now, obviously, we all know about COVID-19. We all know about the chilling effect it's having on how we operate. But have you that knowledge in and of itself isn't likely to be enough, or very often won't be enough, to trigger any particular force majeure clause. You will need to give formal notice to give rise to that right under the contract. So you might be in discussion with your contract counterparties as to how to deal with the impact of COVID-19, perhaps with a view to adjusting your obligations so that they can be performed notwithstanding COVID-19. You might be looking at the PPN model terms of payment to adjust payment obligations. But in our scenario, for example, the university and the summer school may be in discussion as to whether elements of the summer school can be run online rather than on site. Perhaps with that online provision supported by the university in order that the contract can be performed. A little bit like the way this conference is being reorganised today. But whilst those discussions might be continuing in good faith, you should consider whether to issue a formal notice of force majeure, just to make sure that you enjoy the protection of the force majeure clause if those discussions were to break down. And here, timing can be key. It may or may not be fatal to delay and miss the boat by continuing to operate the contract once the trigger events have happened. And you may then start getting into all sorts of knotty legal arguments. On the other hand, there may be good tactical reasons for delaying service of a notice. The important thing here is to get the contract out early on, review the provisions, and make an informed decision on what you're going to do, taking into account the risks in both directions. The force majeure clauses usually offer protection to a party in default under the agreement. Where you're the defaulting party, you should make sure that you've taken the steps necessary as set out in the contract to benefit from that protection if you were to need it. You should also refer to the notice provisions. The force majeure provisions refer to notice having been given to the other party. There are likely to be formalities that need to be complied with on that front. And the email that your colleague sent to their counterpart is pretty unlikely to be sufficient for those purposes. Typically, force majeure clauses also provide a mechanism for termination. So as well as affording the parties protection against their breach of contract arising as a result of the force majeure event, it's common for the parties to also have a right to draw a line under the contract if it runs on for too long, with performance prevented by force majeure. Sometimes force majeure clauses will provide that if the force majeure event continues to prevent performance for more than a specified period of time, one or both parties is entitled to terminate. And typically, the clock starts ticking here when the notice of force majeure is served. We'll discuss considerations around termination in more detail a bit later on, but for now, suffice to say, you need to be very careful before exercising this right, as getting it wrong can be a costly mistake. Next slide, please, so we can look at frustration. If you pull your contract out and find that there's no force majeure provision, or perhaps your force majeure clause isn't capable of covering the COVID-19 scenario, then you might want to consider whether the contract runs the risk of being frustrated. The doctrine of frustration is a test established through precedent in common law and allows a contract to be discharged when an unforeseen event occurs, rendering the performance of the contract impossible, or which radically changes the obligations of the parties. But the threshold for frustration is very high, and the test is strict, and the courts tend to apply it pretty narrowly. And when a frustrating event does occur, the contract is automatically terminated without requiring any action of the parties. The purpose of this doctrine is to avoid injustice where there's been a significant change of circumstance, and importantly, when neither party is at fault for that change. There are broadly three types of frustrating event. First is where performance of the contract has become impossible. So in the context of COVID-19, a lack of availability of transport providers could feasibly make performance of a contract to deliver products to a particular place at a particular time impossible, and thereby potentially frustrated. Second, where the agreed purpose of the contract has become impossible. This is distinct from performance, but the agreed purpose. So in our university language school example, this type of frustration might crop up if, for example, the language school was being run over Easter as part of the attendees' Easter celebrations. If Easter is critical to the event, and the event can't be postponed, June will be too late for an Easter celebration, it wasn't possible to host the event over the Easter period, that may well be a good example of the purpose of the event having become impossible. And finally, where there's a significant change to a mutually agreed state of affairs. And a good example of this sort of frustrating event, though perhaps not entirely relevant to the current circumstances, is the line of what are called the coronation cases that revolved around the coronation of King Edward VII. And here, the mutually agreed state of affairs, there would be celebrations along the route of the King's coronation procession. And when the King fell ill and that procession was cancelled, the contract for the hire of a flat to watch the procession was frustrated. The mutually agreed state of affairs, that the procession would pass in front of the flat, had changed, thereby frustrating the contract. There are some important points to consider when thinking about whether or not your contract might have been frustrated. First, was the risk of this event considered by the parties, either expressly or impliedly, when drawing up the contract? If it was, they'll almost certainly be treated as having allocated that risk between themselves and won't be able to rely on the contract having been frustrated. The presence of a force majeure clause very often have the effect of dealing with circumstances which might otherwise have given rise to frustration. By the same token, parties entering into contracts today are unlikely to be able to point to COVID-19 as a frustrating event rendering performance impossible, as that event is very much in contemplation now. And I should say that having an event in contemplation is not necessary to have the specifics of a global influenza type pandemic in contemplation. Just a very broad category of risk that this kind of pandemic gives rise to is sufficient in itself of having been in consideration of the parties and therefore removing the opportunity to claim frustration. And a good example of the courts treating the parties having already allocated the risk between themselves, even where the specific circumstances weren't in anybody's mind, is the recent case of Canary Wharf and the European Medicines Agency. Here the EMA, which had recently taken out a lease of space in Canary Wharf, argued that the Brexit vote, which would require the relocation of the EMA out of the UK, frustrated the purpose of the lease. But because the lease contained a right for the EMA to sublet or assign the lease, albeit on pretty onerous terms, the court found that the agreement already catered for the scenario where the EMA might wish to relocate from Canary Wharf. And as a result, the contract was found not to have been frustrated. Has the contract taken as a whole been frustrated? or is the intervening event, the difficulties created by COVID-19, a relatively temporary challenge in the context of the contract as a whole? For example, the closure of university facilities of course mean that catering outlets and some outsourced services aren't needed during the period of closure. But in the context of a 4-year contract, it seems pretty unlikely that a 2-month closure, if that's what it transpires to be, would be treated as rendering the performance of the contract impossible. And there's case law, albeit from Hong Kong and the US, in the context of flu epidemics, which points towards temporary inability to perform or enjoy contracted services being insufficient to give rise to frustration of the contract. Could the contract have been performed by other means? The preferred means of performance may have been rendered impossible by the supervening event. But are there other means by which the contract can be performed? And again, one could look at today's conference and point to LUPC's very impressive and speedy reformatting of the conference as a great example of finding a way to perform a contract by other means once the physical holding of the conference had become impossible. So what are the consequences of frustration? I think it's on to the next slide, please. A force majeure event usually only results in a contract being terminated if the force majeure event continues for a long time, and if one of the parties then exercises a termination right. But in the context of frustration, the contract is automatically discharged. This means that all present and future obligations of the parties are extinguished, and it doesn't require any step from either party for that to happen. It just happens as a result of the frustration. Now, of course, if the parties simply drop hands at the date of discharge, that could result in some very unfair outcomes with a windfall to one party or other. One party might have substantially performed its obligations, but the other party's payment obligation may not yet have crystallised. Or in the example of our summer school, the language school might have paid the majority of the fee already, but not yet received any of the benefits of the contract. So in order to level out these potentially unfair consequences, the Law Reform Frustrated Contracts Act 1943 steps in. And broadly, what it does is it works to require the repayment of monies paid before the contract is frustrated. But the recipient of those monies is entitled to retain the amount of any costs that it incurred in the performance of the contract, together with an amount equal to the value of any non-money benefits enjoyed by the other party. But it's worth emphasising that the way in which this levelling out is calculated is the subject of a fair bit of conflicting case law, not least because these issues arise only very rarely. And with the likelihood of us seeing a good deal of frustration-related litigation coming out of COVID-19, it's likely that the basis for these calculations will evolve as a result. Next slide, please.
So if we now turn on to some more practical issues about contract management and practicalities for minimising the risk of disputes. And as mentioned earlier, the majority of our clients and their counterparts are looking at pragmatic ways to deal with the issues. And as a litigator, I can assure you that you really should only be looking to get into any formal disputes as a last resort. It's almost always better to find an amicable negotiated solution. Just because the contract says things will be dealt with in a certain way doesn't mean to be that they have to be. The parties are almost always free to vary the contract. That said, it is of course useful to have an understanding of the strength of your bargaining position before you enter into negotiations, and to be considering ways of minimising the risk if solutions can't be found. I mean, there's a whole host of things that can be done to avoid having to speak to litigation lawyers, and much of it's common sense, but a key point when dealing with things going wrong, take a deep breath, don't allow other people's panic to sway your actions, but equally don't just sit on the issue or put your head in the sand. It's amazing how often people don't look at the contract after it's signed, well, or indeed at the time when it is signed. And this is totally not practicing what you preach. I don't know how many times I've signed up for the iTunes terms and conditions when they're renewed and never once looked at them. But at least at this point, given that it should be fairly apparent that by now, if you have a contract that it's likely to be affected by coronavirus, pull the contract out, carefully consider what it actually says and which provisions apply. As we've already mentioned, force majeure provisions in particular vary greatly from contract to contract. So just knowing that you've got one isn't enough. You need to really drill down into the detail of what it actually says to seek the benefits of protection, or indeed challenge a counterparty's reliance on it. If the contract requires you to make efforts to avoid non-performance, make those efforts. Failure to do so may render any protection under a provision invalid. Potentially agree what those steps are going to be with the other side. It'll be a lot harder for them to argue that they weren't sufficient at a later date if they had agreed for them now. And for that reason, it may be helpful to create a written trail of those discussions. It sounds obvious, but look for ways to minimise your loss. You'll obviously have to deal with the impact of those losses until you win, assuming you do win. And if the parties who are contracting with successfully operate a force majeure provision, their non-performance will not be a breach, and therefore they won't be liable for any of your losses. If they are liable, both the contract and the common law may require you to mitigate any losses anyway, as in keeping them to a minimum, minimising them and taking steps. As mentioned before, both force majeure provisions and frustration can result in contracts being terminated, but please be super careful about this. A really common mistake is getting termination wrong. So let's say, for instance, that your force majeure provision allows for a contract termination after a certain period of time, but it also requires you to make efforts to find an alternative way of performing. If the party decides to simply terminate the contract without making those efforts, or if the specified force majeure trigger events simply haven't occurred, that may amount to, if you try and terminate them, that may amount to what's called a repudiatory breach, basically where you're showing that you're not going to work on the basis the contract is valid anymore. The other side can then terminate themselves and sue for breach without having to fulfil their own obligations. So that could create liability for the whole remaining value of the contract. As mentioned earlier, however, it can equally be important not to delay ending up with your termination, because you may then waive any termination rights you've got. So if you're going to terminate, that usually requires formal notice to be given. So again, look at the notice provisions. The courts go through phases of interpreting contracts pragmatically and through phases of literally. I think largely we're currently going through a literal period at the moment. So whilst this example has nothing to do with force majeure, it's just an interesting example of the court's literal interpretation of termination notices in a case called Flanagan and Lyons Trust. That was about a partnership. It was about termination of a partnership and getting rid of one of the partners. The contract said the notice period is 6 months. Notice was then sent on the 20th of August 2012, and it said, please accept this letter as notice. You'll cease to be a member with effect from the 4th of October 2013. So they'd given him, 15 months? But the court said no, that was invalid. The contract says the notice period is 6 months. It held that it had to be exactly 6 months. Next slide, please. Also check any time limits in the contract. Has the force majeure trigger event already happened? There's a couple of examples of what this could be. Was it the declaration of COVID-19 as a pandemic by the World Health Organization? I think that was on the 11th of March. Was it when it became a notifiable disease in England on the 5th of March? Or is it going to depend on the ongoing UK government announcements about the continuation of lockdown? Is performance already affected, or is it just that it might be in a month or so's time? There's obviously a lot of uncertainty on this front at present, given the relatively short 3-week window for the lockdown reviews. If your opponent's threatening to pull the plug and you don't believe that they can, you might need to consider whether you need to seek an urgent injunction from the court requiring them to continue to perform. I would urge you to think very carefully indeed before going down that route. Injunctions are very expensive and difficult to get, but it might be your only option. So if so, the applications for an injunction need to be made without delay. That's one of the grounds that the courts will look at in determining whether you can even have the injunction or not, regardless of the merits. Clearly, a factor in deciding how you're going to proceed is working out how much the issue is worth, both financially and reputationally. The aim must be to find a solution that's going to cause the least overall damage, and obviously legal costs and publicity also need to be factored into that picture. How will your stakeholders and students respond to the issue once it becomes public? It's almost inevitable that at that point there'll be social media commentary, so work with your comms people to manage this and the publicity surrounding any cancellation. And also coordinate the approach to the issues across your organisation. Decisions taken in relation to staff, working practices, they may well have an effect on service delivery. And a coordinated approach between all parts of your organisation will help you identify, manage and mitigate risks early, and also to avoid mixed messages, particularly to third parties. Next slide, please. It's also important to consider insurance policies. Those that you might be most interested in would be business interruption, event cancellation, liability, and legal expenses insurance. I wouldn't get overly excited at this point. I suspect that the majority of policies will have wide-ranging exclusions, but it's clearly worth checking. If they do kick in, the requirement's usually to notify your insurer when you become aware of circumstances that could give rise to a claim. There was an article in the Times about a week or so ago which said that Wimbledon has virus insurance cover. Essentially, after the 2003 SARS scare, they got virus cover added to their policy, which at the time wasn't really something people were insuring for or against. And with an alleged premium of £1.5 million, that looked extremely risk averse, even to a litigation lawyer. However, the article then went on to say that they're apparently putting a claim together for a payout in excess of £100 million, whereas the French Federation of Tennis don't have that clause and stand to lose about £230 million from the cancellation of their event. Insurers may well take some time to confirm the coverage position. Unless and until coverage is confirmed, you should act as a reasonably prudent uninsured, which basically means that you shouldn't do anything that will prejudice the position of your insurer without their prior approval. It may also be that the case that any costs you incur before the insurer gives a go-ahead aren't covered. Depending how the situation pans out, you may also want to consider whether you need to notify your regulator. So I think most of the attendees here are at universities, so that's likely to be the OFS. And if the situation is really not good, whether you need to consider making a serious incident report. While you quite rightly probably have no intention of getting into formal dispute over any issues with the contract, it's nevertheless sensible to understand what that would entail, as it could assist and influence the way discussions go. What are the dispute resolution procedures in the contract? If you're hitting a brick wall with your counterpart, does the contract provide for an escalation process, so that effectively you can go to their boss, pointing that out as a contractual step to avoid putting their nose out to joint? Does it provide for arbitration rather than court litigation? That would mean that the dispute wasn't going to be in the public arena, and that might make a significant difference to how this is viewed in terms of its risk profile, either by your institution or by a supplier. Next slide, please. It might be that you get embroiled in a formal dispute, and you're going to have to think about what evidence you might need. Now, achieving the best outcome, both at court and in negotiations, is often dependent upon presenting the best evidence available to support your position. So take steps to ensure that evidence is identified and preserved early, at an early stage, especially as disputes can go on for years. Not only because it's crucial to supporting your argument, but also there's a duty on parties to preserve evidence, whether it supports your claim or not, when court proceedings are contemplated. Be careful about creating new documents that undermine your case. Those may well become disclosable if there's any litigation going on. So bear that in mind when internal emails are firing back and forth, particularly given the uncertainty of the situation and how it's going to be dealt with by the courts. Also bear in mind who your witnesses might be. Now, it might seem far too early to be thinking about this properly, but again, within large organisations, it can be about coordination of various teams. Clearly, we're all hoping that furloughing will be the most that anyone has to do, but the reality is that redundancies may at some point be considered, and or employees may otherwise leave. If someone's critical to the issues that have been raised by the coronavirus issues and they're about to leave, particularly if it's not of their own volition, it might be a good idea to get a statement from them while they're still amenable to helping. Now, hopefully most of this can just be for strategic use. The best solution to any disagreement is almost always to find a pragmatic solution that doesn't involve formal disputes. In many cases, the application of a force majeure clause to a particular circumstance facing your institution isn't going to be clear-cut. Discussions can be held on a without prejudice basis. That's basically where you're trying to reach a compromise settlement. And anything you say in without prejudice discussions can't then be used in evidence against you if an amicable solution can't be found. Formal court proceedings that go all the way to trial may well cost a six-figure sum. And is it really worth the cost, the management time, and the inherent risk of all litigation, as opposed to minimising the risk and gaining some certainty? Clearly, informal discussions can help find a way forward that works for both parties and maintain the relationship. If you do find a sensible solution, make sure it's properly documented. Again, check the contract. Are there formal requirements for variation and change management that need to be adhered to and or documented formally? Litigation is expensive and it's time consuming. It's almost always the case that the only people that win from litigation are the lawyers. You almost never get all your costs back, even if you have an emphatic victory. So some form of compromise is almost always sensible. But just for me to end on a positive note, the vast majority of the stuff that comes across my desk as a litigation lawyer could, in theory, go to court, go to trial. They almost always settle. It's been 15 years since I've had a fully contested trial that's gone all the way to a judgment. So there is almost always hope, if you've got commercial parties, that you'll find some sensible solution.
Thanks, Ben. So that's about it from this session. Before we wrap up, I think there are 3 takeaway points that Ben and I have identified for you. The first is that force majeure is just another contractual term. The extent to which you might benefit from its protection will depend entirely on what your contract says and how the clause is drafted. So don't make any assumptions about it. Read the clause in the context of the agreement as a whole in order to understand what your rights are and those of your suppliers. The second point is that I think we're hearing a bit more sort of in the legal media, certainly, and possibly in media to which you're exposed, around frustration. And frustration is certainly there in the background, and it might step in where a contract has become genuinely impossible to perform. But the circumstances where frustration does kick in are pretty limited, and the consequences, which are to bring the agreement to an immediate grinding halt, will be quite profound. So we expect this right, or this mechanism, to apply only pretty rarely. Finally, whatever the strict contractual position, even where the PPNs don't apply, our view is that a cooperative, pragmatic approach when dealing with suppliers and customers is going to be the preferable route, certainly in the early stages of discussions. Yes, there are things you should do to make sure that you understand your position and that you protect it as best you can, but finding a way to work through these challenges in a way that allows you and your contract counterparty to emerge from this lockdown on a sound contractual footing for the future, that seems to us to be the right priority. So I hope that's been a helpful run through some of the legal and practical considerations that you should be thinking about when reviewing your contracts in the context of the challenges that COVID-19 has created. That's it from me and Ben. Thanks for your time. And I think in a few minutes we'll be responding to some questions that I've seen have been coming in whilst we've been talking, and perhaps also to some that came in earlier in the week that we haven't picked up this morning. So thank you very much.
Thank you.
Thanks very much, Ed, and thank you very much to Ben. That was an excellent session again, and you covered so much in such a short period of time. We're very grateful.